Someone is speaking. plea was taken by the state earlier. Then DB, learned DB of the Honorable Gauhati High Court has decided against them, same issue, identical issue. So now they are saying that similar issues are pending in other DB cases also. They can go on, single benches are deciding against them, they can go on filing LPS, letter patent appeals before the DBs, and then will not allow my case to be decided forever, next 10 years. And the person will die, she's already 70. I mean, she's suffering. Let them give some interim relief at least. Some provisional pension would be given, then they can take their time. They don't want to give any interim relief. For last 2 years, I'm begging before this court. They are not ready even to spare 10,000 rupees a month.
How can provisional relief be given when it is not decided?
File a writ petition.
When the merit is to be decided.
Writ jurisdiction can always be invoked for such a direction. It is a writ court.
No. What I mean is the merit. If you don't have merit, then how can the provisional
mandate come from the directions of the court? That on that point I will assess. So I'm only praying that let this matter be taken up at the end of the court. I will assist all these issues I will clarify. I mean, certainly I cannot ask something which law does not permit. Nor my sister will allow me to have anything which law will not permit. So
you're giving dispute contradictory
statements. In that case,
so we have to go.
Earlier they took the same plea. DB matter got decided.
Otherwise, counter affidavit is filed.
Everything. In fact, the last order may kindly be seen. Last matter has been kept for final hearing. So they are saying similar DB matters are coming again. But once there is one DB judgment, unless the next DB disagrees with the earlier DB, it will follow. The rule of precedence is very clear. So this can be decided. Otherwise, my interim relief may kindly be decided, I will seek my remedy before the Honorable Supreme Court.
We'll see whether we can take up or not. Okay, you just wait.
Yes, Mr. So I'm going to court number 2.
We'll see.
Yes. I will come. All right, good.
For motion, item number 1.
May I please, Your Lordship?
Yes.
Your Lordship, the brief facts of the case is that in the year 2016, the petitioner firm initiated to set up a manufacturing unit of polythene bags. And for the said purpose, the petitioner firm initially obtained trade license from the respondent number 4. And thereafter, the petitioner applied before the executive engineer, Dimapur Electrical Division, for power supply, Your Honor. That was also provided, Your Honor. And thereafter, consent to operate the said was also obtained from Nagaland Pollution Control Board. Nagaland Pollution Control Board also given the consent, which was a license was obtained from them, and the same was also renewed from time to time. And for the said purpose, the petitioners to set up the factory initially availed a loan of 1 crore 25 lakhs, Your Honor, as cash credit. And the petitioner also invested and incurred various expenses in this regard, Your Honor. Now, after setting the factory,
no, but
with due approval
how can, Learned Counsel, how can this court help you? Because there may be thousands of other plastic factories who have also set up.
Yes, Your Honor, because
how does it concern the court that you have set up a plastic factory?
We have set up the factory and notification was issued, Your Honor, Your Lordship. A notification was issued, notification dated 29/11/2018, that is my annexure 6. According to this notification, Your Honor, a paper publication was issued from complete ban of the manufacturing unit of plastic bags, which eventually led to the closure of my business, Your Honor. And according to the crucial situation, you know, my bank, the bank from where I have availed the loan, that also increased, Your Honor, and eventually it has turned to NPA. And the bank has come up to recover the dues, and a judgment has also been provided. A judgment has also been against me, Lordship.
That's why I'm saying there may be hundreds of plastic factories, and who had foreseen that such a ban would come? So they may have been functioning already. So how do we interfere in such a case?
No, Your lordship, the thing is that when the license and all NOCs were issued by the concerned department, it was a promise to me that the government has issued the notices, each and every license and each and every documents I have taken from the government itself, and they have issued the license so that I can start my factory. And initially I have started also, and I was doing my business, and suddenly they have come up with such a notification, and a total ban was imposed, your lordship. Subsequently, some other notifications also have come to know, such as notification dated 17/6/2019 and 11/3/2022. Those notifications are also in regard to the banning of the plastic, Your Honor. My say is, Your Lordship, some remedial measures should have been taken before complete ban, because it was a initial stage of my business, Your Lordship, and government did not come up with any such measures so that the losses may be minimized, or they may have been given some time so that we can operate up to some time, or a limit, so that up to so and so date we may extend our business, and after that they may have closed our business. Nothing such was done, Your Lordship, and a total ban imposing from the very date was provided. So in that regard, the dues of the bank has also increased, and now the bank is after me to cover my dues, Your Honor, to recover the dues. And I have also mortgaged my property. They are trying to sell my property, Your Lordship. That is why I am in a total loss, Your Honor, in regard to the ban that has been imposed in plastic bags, Your Lordship.
No, I don't know how this can come under jurisdiction. Anyway, we will issue notice. Who's appearing? Yes.
Lordship, before
Yes.
issuing the notice,
Yes.
Your Lordship,
Mm.
let me point out one thing here, Lordship.
Mm.
Lordship, may kindly come to page 66.
Yes.
Page
Yes.
66, Your Lordship.
Yes. Mm.
The notification banning the use of plastic
Mm.
has come into effect because of the rules, Plastic Waste Management Amendment Rules 2021. This was issued by the Ministry of Environment, Forest and Climate Change, Government of India.
Mm.
So the ban is not by the state, the ban is by the union under ruled Waste
Plastic
Management
Waste
Amendment Rules
Management.
2021. If I may be allowed to read just the first para, Lordship.
Mhm.
In partial modifications of this department notifications dated 29/11/2018 and 17/6/2019, and in pursuance, Your Lordship, see, and in pursuance to Plastic Waste Management Amendment Rules 2021, notified by the Ministry of Environment, Forest and Climate Change, Government of India, notifications number such and such, dated 12/8/2021, in the Gazette of India, prohibiting identified single-use plastic item which have low utility and high littering potentials by 2022. That the government of Nagaland is pleased to impose ban on single-use plastics in Nagaland with a view to eradicate the menace of plastic and the serious environmental and economical changes posed by rampant use of plastic. So the ban is because of the rules 2021, Your Lordship.
Yes, yes. Then why should the state
Yeah, but-
compensate you?
Yes, Your
Why should
Lordship.
the state compensate you?
And they are not challenging this rule.
Lordship,
Plus,
I would,
you have not impleted the
Union of India.
Union of India, the concerned department.
They are challenging.
Yes.
Lordship, I would like to,
Untenable at all.
Lordship, I would like to take your Lordship to page number 19, Your Lordship. Page number 19 is the trade license, Your Lordship. The trade license has been
That can be
issued.
given to anybody. That
yes.
can be given to anybody.
Yes.
Not only
Right,
to
Your Honor. The Lordship, that is 15/1/2016. for
everybody
plastic.
needs a trade license, Mr. Counsel. Everybody needs a trade license to operate
in fact-
companies.
Correct.
Understood, Your Lordship. In page number 20 also,
This is
dep-
untenable at all.
You either withdraw and
Yes.
refile, or I'm dismissing it.
Lordship,
Because we
then
have
I would
not-
like to withdraw and
You have not challenged the plastic waste management rules under which this order was passed. You have not implemented the Union of India.
Who have notified them?
Yes.
Your Lordship, in that regard, I would like to withdraw the petition and and we'll file it fresh, Your Honor.
You better do that. The learned counsel for the petitioners, research and such, prays for withdrawal of the writ petition with liberty to file afresh, if so advised. Accordingly, petition is disposed of on withdrawal. Liberty is
Obliged,
given
obliged,
to the petitioner to file afresh, if so advised.
I'm deeply obliged.
obliged.
For admission, item number 2.
Yes, item 2,
Yes, Your Honor, and happy son.
yes.
On behalf of Tiba,
Hmm.
pray for 3 weeks to file affidavit in opposition for the state.
Oh, counter not filed.
Not yet.
Any objection? Okay. Learned government advocate M. Longcomer prays for 3 weeks' time to file counter affidavit on behalf of the learned government advocate Tiba Pom, who is appearing in this matter. Learned counsel for the petitioner has no objection. This is the matter after 3 weeks. The interim order passed earlier shall continue till the next returnable date.
Obliged. For admission, item number 3.
Mr. Lordship,
Yes.
for a respondent number 1 year, I may be given 2 weeks time to file my counter.
2 weeks' time.
2 weeks time.
Learned counsel for the respondent number
One.
1, MS such and such, prays for 2 weeks' time to file the counter affidavit. Stop. Learned counsel for the petitioner, MS such and such, present and has no objections. List after 2 weeks.
Leadership does interim.
The interim order passed earlier shall continue till the next date.
For admission, item number 4.
Yes, Your Lordship. Lordship, the petitioners were allowed to file their amended petition
Mm.
by including the chief secretary, and we have received a copy
Mm.
only recently, Lordship. So if 2 weeks were granted, Lordship, to file our objection to the.
Amended petition filed.
Yes. The chief secretary was not made a party in the case
Okay.
because the order was issued by the chief secretary.
Mm.
Now, Lordship, this is a function of policy decision of the government,
Mm.
where the government has framed certain policies as far as the appointment of landowners.
Yes.
Now the petitioner is challenging the policy.
Oh, the 2018 policy.
Yes. The grandfather has taken the money, then compensation. The grandson is asking for employment.
Okay. Council, now you'll be
Yes, Mr.
appearing,
Lordship.
yes.
My lord, regarding private respondent number 7,
Hmm.
we have issued fresh notice through Dusty Service.
Hmm.
And to that effect, we have filed a affidavit on 15/7/2025.
Who's respondent 7?
Private respondent.
Oh, actually,
Now they are challenging the appointment of private respondent who was
Achha.
appointed on compassionate ground.
okay, okay. And you are mentioning for our,
Respondent number 1, 1, 4,
1, 4,
and 6.
and 6. You want to file counter to the amended petition.
Yes.
Hmm.
In fact, Lordship, I'll be filing my objection as to the
Objection.
petition.
Objection, counter, whatever.
Yes.
Yes. Learned counsel for respondent number 1, 4, and 6, Mr. N. Mose has prayed for how much time?
2 weeks.
2 weeks' time to file objection / counter affidavit to the amended writ petition. Stop. It is stated by the learned counsel for the petitioner that service on respondent number 7 has been taken through Dusty mode, and affidavit to that effect has been filed. Stop. Today, when the matter is called, none appears for the respondent number 7. Stop. Accordingly, the service on respondent number 7 is deemed served. Stop. List the matter after 2 weeks in order to enable the respondent number 1, 4, and 6 to file their objections.
Pleasure, Lordship.
Oh, who appears for government? Oh, okay, okay.
Your Lordship,
Learned-
for respondent number 3
Learned senior government advocate Moying Chin appears for respondent number
and 5.
2, 3, and 5.
Fine.
For admission, item number 6.
Status report with regard to the payment of.
Yes, Your Honor, I have instruction from the department that this matter would take some time. For the release of the heirs and payment.
Hmm.
So I pray that if the petitioner is willing, we can dispose of the matter by giving a time frame.
Acha, acha. Is that okay? Because it's not disputed, na?
No, it's not-
Hmm.
A specific period may be given.
Yes, how much time?
I think it's 3 months.
3 months. The present application has been filed under Article 226 of the Constitution of India, praying for release of arrears of salary with effect from 2/1/2020 to 30/11/2024 in respect of the petitioner's late husband. Stop. I've heard learned counsel for the petitioner, Mr. such and such, and learned government advocate M. Longkama. Stop. Para. The case of the petitioner is that by an appointment order dated 21/12/1989. Please correct me on the facts and dates and all, okay, if there's a mistake. By an appointment order dated 21/12/1989, the petitioner's late husband was appointed as Chokidar on a fixed pay of rupees 375 per month under the establishment of the Subdivisional Officer PHED, Longleng Division, Nagaland. Stop. Thereafter, by an office order dated 15/1/2020, his pay was upgraded to
Work charge.
work charge khalasi in the scale of pay of rupees 3,000 to 15,200 per month, with grade pay of rupees 1,300 as per an administrative approval of the government dated 14/1/2020 with effect from 1/1/2020. Stop. Subsequently, his service was regularized by an office order dated 13/9/2024. 2024. Stop. However, the petitioner's late husband was released from service on 25/11/2024 with effect from 30/11/2024 on completion of 35 years of service. Stop. Para. It is stated that the petitioner has obtained the death certificate of her late husband and thereafter a succession certificate from the Court of District Judge Longleng, Nagaland on 7/1/2025 to claim the service benefits and pensionary benefits payable to her late husband. Stop. Thereafter, the petitioner submitted a representation dated 22/2/2025 before the Chief Engineer PHED Nagaland Kohima requesting for release of arrears of salary with effect from 2/1/2020 to 31/11/2024 in respect of her late husband, Shri H. Chauba, CHAUBA, Chauba Phom, Khalasi in the Office of Executive Engineer PHED Longleng Division. Stop. However, the petitioner's representation was not considered. Stop. Being aggrieved, the petitioner is before this court. Stop. The learned government advocate, Sri M. Longkamar, has submitted that the government is not disputing the fact that the arrears of pay as claimed by the petitioner is admissible to her. However, the matter is under process and it will take some time to release the said arrears. Stop. Accordingly, he has prayed that some time may be granted to the state respondents to release the same. Stop. Para. in view of the fact that the claim of the petitioner,
Your Honor, if I
Yes.
may,
Yeah.
if you can add one more line, and
yes,
with regards to the release order,
mm,
there was some typing error in the petition.
okay,
So it has been rectified by a
Page 12,
Subsequent
page
order.
12 of my petition.
page 12 of the petition. This is the initial release order, which said that that's the release.
30/11/2024,
It has now been rectified as 13/8/2024. I've also placed this on. a
where is that rectification? Learned, come to that government advocate submission, okay? Learned government advocate also submits that in the writ petition, in the writ petition at annexure A4 in release order dated 25th November 2024, the date of release is given as 30/11/2024. Stop. However, the same has been rectified by another order number EE/PHE/LLG/EST-1/2024-25/02 dated, what date is this? Dated nil September 2024, by which the date of release has been rectified as 13/8/2024 instead of 30/11/2024. Stop. Then next para, you come. And what did I say? In view of the fact that the prayer made in the writ petition is not disputed by the state respondents, the petition is disposed of at the admission stage with a direction to the respondents number 3 and 5.
3, 4.
2, 3, 2, 3 and 5. Respondents number 2, 3 and 5. No, I think it should be only 3 and 5 because he's a 4th grade employee, no? So respondents number 3 and 5 to release the arrears, the area of salary of the petitioner's late husband with effect from 2/1/2022. So it will be the new date now.
13/8.
To 2/1/2020 to 13/8/2024. Within a period of
3 months from.
3 months from the date of receipt of this order. Petitions disposed, yes.
For orders, item number 7.
Your Honor,
Yes,
I'm waiting on one more instruction from the department, so I wait for 3 weeks to file my affidavit, Your Honor.
what is this landowner?
Yes,
Counterfiled.
not yet, Your Honor.
Not yet. 3 weeks.
This one.
3 weeks time. Okay. Learned,
So Lordship,
yes.
Lordship, on 14 July of 2025, one notification was issued for verification whether the petitioner grandfather was the landowner or not. And in 16 July, the verification was conducted, and in that report, it states that the petitioner grandfather is the landowner. If I may be allowed.
No, but here on 19/6/25, the
Yes.
court had directed the government to file the verification report in the form of an affidavit.
Lordship, this is the latest verification report again.
Oh, after that,
But that is, this report is not from the DC, from the authority. This is from a letter from a CMO. So I have to verify.
get from the DC.
Yes, the verification.
Actually,
report
it
is
should
from
be DC.
DC.
Yes.
So the
If
DC's
the
final
government
report
can
is.
also get instruction regarding this notice.
Okay, you give them a copy also. Yes, yes, yes. Learned government advocate, Mr. M. Longkamar, has submitted that he needs further instruction with regard to the verification report from the deputy commissioner of the concerned district. So accordingly, he has prayed for 3 weeks' time to file the said report in the form of affidavit. You file it as affidavit, okay? The report. You file it in the form of an affidavit.
Yes, Your Honor.
To file the verification report in the form of affidavit as directed by this court on 19/6/2025. Stop. Accordingly, the government advocate is given 3 weeks' time to file an affidavit in respect of the verification report. Stop. Yes. 3 weeks.
For orders, item number 8.
May I please, Your Lordship?
Yes.
Lordship, I'm for respondent number 2 and 3.
Hmm.
Your Lordship, their affidavit is ready, signature is awaited. So I pray that 1 week time will be given.
2 and 3. And state,
I'm yet to receive any instructions. I'll pray for 3 weeks, Your Honor.
learned counsel, Mr. Your name?
Mr. Kaji.
Nisuka, appearing for respondent number 2 and 3, has submitted that the counter affidavit is ready, but he is awaiting the signature of the deponent and prays for 3 weeks' time to file the affidavit on behalf of respondents number 2 and 3. Stop. In the meantime, the state, the government advocate M. Longkamar also prays for 3 weeks' time to file the counter affidavit. No, just say the government advocate has made a similar prayer. Similar prayer. Accordingly, list the matter after 3 weeks.
From the supplementary cost list for hearing, item number 10.
Yes. Hmm. Yes.
Before coming to the appointment, if I may be allowed to narrate the facts of the case,
Mm.
how the petitioner report is now before.
Hmm.
I've stated in my paragraph 5 of the read petition, which also will find at page 7.
Yes.
Page 7, paragraph 5, may I read it?
Yes.
That the petitioner backs to state that in the year 1960, the petitioner's grandfather, so donated some acres of land to the state government for the establishment of the office of SDO, PWD, Kohima, and several other departments under the state government. The land is situated in Kohima, and which falls under the jurisdiction of so, and the same was donated free of cost by the petitioner's grandfather without claiming any land compensation. It is pertinent to state that in the same vicinity, another landowner, Shri so-and-so, had also donated a plot of land in favor of the department of PWD, and in no such gesture, the department has given service benefit on 3 occasions. So that fact is not disputed. The state government, they have also filed the affidavit,
Hmm.
and they have also enclosed the appointment orders of the 3 appointments. And that is pertaining to the co-landowner
Hmm.
who has donated land in the same vicinity for the government of Nagaland. Now, my respectful submission before this and on the board is that the 2 landowners, they have donated land.
Hmm.
There was an oral agreement in the year 1960 between the government and the landowners.
Hmm.
Oral agreement. And in good faith,
The other landowners also don't have written
No
agreements.
written agreement. Now, in good faith, they have executed such agreement between the government and the landowners.
Mm.
Maybe it is my assumption that maybe the other four landowners, they were more influential or they were more educated. So they approached the department and they were able to get appointments on 3 occasions. Whereas in my case, I waited for the right time. I waited for the opportunities where I never got the opportunity to get the employment. It was only in the end, 2023,
Mm.
the petitioner, the present petitioner and his family, they came to know about a vacant post which was lying in the department.
Mm.
The post, it became vacant on 30th of June 2023 on the retirement of an employee under the division. Now it was a grateful post, and now this days it is the nomenclature is changed as MTS, multi-tasking staff. So that is the post.
Became vacant in 2023.
Yes. So the moment I came to know about the vacancy, I submitted an application
Mm.
before the concerned authority.
Mm.
My application was also supported by a certificate issued by the village council,
Mm.
which is the statutory body and a village. Now, the village council had clearly stated in the certificate, which was enclosed in the application. If I may be allowed to refer to the certificate which was issued by the village council, page 18.
Eighteen.
1818. This is
Yes.
dated 15 October 2023.
This
This-
is village council.
Yes, Michelin Village Council.
Mm.
So this village, Michelin Village, is also one of the landowners of this Kohima town.
Mm.
Now, this, the village council, they have issued a certificate, this is to certify that she is so and so, that is the present petitioner, son of so and so. He's a permanent resident of Michelin Village. He is the legal landowner of the present Department of Engineering Office. PWR here, under Zinogoda district. So this was issued by the chairman of the village council, as well as it was this by 7 DPs of the village.
Okay.
So a statutory body, having the knowledge that the present petitioner is a genuine landowner, they have issued a certificate stating that he is one of the landowners.
Mm.
Now,
Okay.
after submitting my application, I was under the impression that my application will be considered.
Mm.
But to my surprise, the department has issued an approval on 21st of December 2023, page 24. Page 24. Instead of considering my application, someone else was approved for appointment. By this approval letter, it has approved, the government has approved 9 candidates.
Mm.
19, my apologies, page number 24. Approval for appointment to post
Yes,
of grade
private
4 to the NP.
responsibilities.
It's a government approval letter,
Page.
24. Page 24,
Yes.
24.
Mm.
So this is dated 21st of December 2023.
Mm.
This is approval communicated to the engineer. I'm directly referred to the license number sorry. So on the subject cited above, it convey the approval of the government for appointment in respect of the following persons to the vacancies indicated against the names subject to the condition that the post vacancies are clear. Now the response number 6. Her name features in serial number 19, the second, the next page. The last person in the table, Chairman so MTS. So her name was approved for appointment to the post of MTS.
Okay.
It has also clearly indicated the retirement vacancy. The person who was serving as a peon, Chiri Sorenso's Lu Kobi Sema. Peon retired on 30th of June 2023.
Mm.
It so happens that this person was also one of the landowners. The candidate of the landowners.
Well, the one who retired,
Yes,
he was also a landowner.
yes. Now in pursuant to the approval, interim appointment order was issued on 22nd December 2023. The very next day, after the approval was issued, the next day, the order was passed by the appointing authority, page number 26. Page number 26 is dated 22nd December 2023.
Page 26. 22, 12, 23. Okay.
The order dated 22nd December, page 26. Principal upon the approval of the government, white letter number so and so, dated so and so, in the interest of public service, the incumbent mentioned below is hereby appointed as monthly business staff.
Okay, basing on that approval
Yes.
order, she was appointed.
So one thing is very clear by this approval as well as the appointment order, no selection process, and this respondent number 6, she's also not a landowner.
Mm.
She's not a landowner, and there was no selection process. This appointment order was issued merely on the approval issued by the government.
Mm. But first you have to show your right to challenge the appointment of the
Yes.
respondent number 6.
Now coming to the subsequent agreement between the landowners, page number 19. 19. Page number 19, this is a agreement. Deed of agreement. Page number 20 will be the type copy of the final page, the type copy page number 2. This agreement was executed on 30th of June 1989. May I read it?
36, 1980.
36, 1989.
Mm.
In addition to the land given earlier in 1960 to the government free of cost for the 10th circle headquarters, which has been already surveyed and demarcated by the government in 1975. We, the undersigned GPs, village council chairman and members, as well as the landowners, on behalf of all public and concerned landowners of Mishnami village, to hereby agree to give as much land as government requires for subdivisional headquarters for various development work under the following terms and conditions. Condition 1, that the addition requirement of land for SDO headquarters is also given free of cost to the government. 2, the land is given purely for government development work. 3, the landowners should be given facilities for government contract work and grateful post in various department at Poguto as per rules. So the clause 3 is very clear. Contract works or grade for appointments.
Mm.
The boundaries of the given land given for SDO headquarters are as follows, so and so. So this was signed by the GPs as well as the chairman of the village. Landowners have also signed in this agreement, though the name of the landowners are not legible in this copy. So in support of this agreement, thus land ownership certificate was issued in the month of October 2023 by the same.
Here also, your father is also there in this 89 agreement.
89 agreement, my grandfather.
Grandfather.
Even otherwise, the village council, they have clearly stated that the petitioner, son of Mrs. So and so, is a bona fide landowner. That is not disputed. And even the government, they have also filed their affidavit. They have not disputed with regard to land ownership.
Okay.
The only contention is that
Already 3 appointments made.
But Lordship may kindly appreciate the fact that three appointments were given, that benefit was given only to the core landowner, not the present landowner.
But you interpret, how to interpret 3C? That is the question.
Yes, yes.
Yes,
Yes,
because it
3C
says, it only says the person first appointed as landowner in government service. Okay, so
Yes.
it doesn't say from this clan, that clan, or from among the other landowners, nothing is there.
I agree.
Yes.
It is silent on, in fact, it's silent on such kind of an instance
where if there are more than one landlord,
Exactly.
that is silent.
In other and in similar other cases, this court has already said that only one can be accommodated. So how can this court again deviate from the earlier stand?
I have also,
It has to be consistent.
yes, I have also
Yes.
gone through a judgment by
Yes.
and also I'll be relying on a different judgment.
Mm.
No, if
If it is a division bench judgment, okay.
given this kind of a scenario, if I may be allowed to, if I may allowed to make a humble submission before this honorable court,
Mm.
when there are more than one landowners,
Mm.
the other landowner they have already enjoyed, and in good faith, because at that relevant point of time.
No,
people were-
I understand what you're trying to say.
Yes,
But as far as the court is concerned, the
Yes.
court is bound by this notification.
yes,
We cannot go beyond this. That's the problem.
yes.
Mm.
So
If at all, the only relief that this court can give is that maybe as per the agreement, it also says contract works, etc. So the department is at liberty to consider the petitioner's case for the future, all those contract works.
this honorable court, of course,
Mm.
the coordinate bench of this honorable
Mm.
court. It has passed a direction to the respondent authorities
Mm.
in the case which I'm going to rely upon
To verify.
to verify.
To verify. As per 3B.
Because this honorable court has also taken into consideration 3B.
Yes,
3C.
yes, of course. Government, what is your stand? I guess that's your stand, only that landowners already accommodated. Mm,
The notification is very clear
mm,
on that.
mm. That's why I'm saying 3C.
And if such benefit is not given, it will be quite.
Let's see the other judgment.
That will be number 58 of 2023. What is the number? I'm going to say on this. This also pertaining to under most of the district. Maybe from paragraph 4, page 4.
Mm.
Page 4.
Yes.
Mr. So-and-so Learning Council submits that 3 families have donated the land for setting up the sub-center concerned, and the father of the petitioner was one of the landowners who had donated the land. The Learning Council submits that the state notification dated so-and-so, same notification, by which the state government is legal requirements considering appointment on the basis of land ownership. The same is a policy decision of the state government in view of various claims made by the landowners for appointment to grateful cause, referring to clause 3B and C of the state notification. The Learning Council submits that if there is any such claim for providing employment as a result of some sort of an agreement, including oral agreement, the department concerned is required to report a matter to the deputy commissioner of the concerned district, who shall then examine the claim carefully by taking all relevant factors into consideration, including the written statements from the witnesses, who may be the government officials of the concerned department, the district administration, and the village functionaries. Fine. The Learning Council submits that there is also a condition provided that as it is not the intention of the government to provide employment to landowner in perpetuating upon the retirement of employee concerned, appointed on land ownership basis, the vacancies to be filled through open advertisement in consonance with the existing policy of the state government by giving equal opportunities. Vacancy goes by the retirement of the incumbent concerned in the post of medical attendant. The petitioner was not given an opportunity to consider for appointment despite being one of the families which donated the land for establishing the sub-center. The respondent authorities also did not go for open advertisement as it is required under paragraph 3C of the notification. He submits that the OM dated so-and-so may provide dispensation of advertisement, but the same is subject to there being some difficulties that may be faced by the department concerned in adopting the procedure of an open advertisement. However, in the instant case, there is no such mention about any difficulties faced by the department, and therefore the administrative approval and the appointment order issued in favor of respondent 6 is only selective
and arbitrary and therefore should be set aside. 6. Ms. So-and-so, Leonard State Council, by referring to the affidavit in opposition filed by the state respondents, submits that 2 landowners have already been appointed similar case, and therefore there is no question of appointing a third person from amongst the landowners. In this connection, the Leonard State Council refers to the appointment of was initially appointed to the post of so-and-so, but he sought for voluntary retirement, which was granted to him, and in his place, his son was appointed. Therefore, no further appointment from landowner is called for as claimed by the petitioner. 7. Mr. So-and-so Leonard Council for Respondent 6 submits that since a vacancy arose due to the retirement of one so-and-so from the post of medical attendant under the Unger Sub-Center, and accordingly the Respondent 6 applied for a post with the recommendation of the Village Council of Unger Village Council. The respondent government, upon considering the recommendation made in favor of Respondent 6, granted approval of her appointment, and therefore there is nothing wrong with the order of appointment issued in favor of 6. I have considered the submissions made by the Leonard Councils for the rival parties and have perused the materials available on record. Facts that disputed in this petitioner that the petitioner belongs to one of the family which donated land for establishment of Unger Sub-Center. There were 3 landowners, including the father of the petitioner. So far as one of the landowners, Shri so-and-so, is concerned, his son has been appointed as medical attendant under the sub-center wet order so-and-so. A perusal of the same would go to show that the initial appointment was in favor of Mr. So-and-so himself, but he has applied for voluntary retirement. His son so-and-so has been appointed to the same post. Although the state council has submitted that 2 appointments have been made in favor of the landowners, but it appears from the order dated so-and-so that it is basically 1 appointment since the son has been appointed in place of his father, who retired on voluntary reasons. Notification dated 5th March 2018, clause 3B and C provides a center. B. If there is any claim for providing employment as a result of oral agreement, the department concerned shall refer the matter to the Deputy Commissioner of
You can skip this.
Para 10.
Okay.
From the above abstract, it may be seen that in case of a claim for employment on the basis of land ownership, the Deputy Commissioner of the district is required to examine the claim by considering all the materials that may be available, including the statements of witnesses of officials of the department. The district administration and village functionaries present at the time of such an agreement claim to have been made. The further condition provided under clause 3B is that appointment on the basis of land ownership will be limited only to the first person appointed on advertisement. In the present case, it appears that such consideration was not done prior to filling of the vacancy post by one so-and-so in the post of medical attendant by taking into consideration the case of the landowners. Although one appointment is permissible to be made from the landowners, but the claim of the petitioner herein is that there were 3 landowners who had donated the land for setting up the sub-center concerned, and therefore the petitioner, being the daughter of the landowner, has the right to be considered under the provisions of 3B of the notification dated so-and-so. It is further noticed that as per the OM dated 3/3/22, advertisement can be dispensed with on account of such difficulties that may be faced. This is not disputed in this case. In fact, this question was not raised. However, from the materials available in court, such difficulties faced by the department is discernible. Therefore, the administrative approval granted in favor of Respondent 6, in the absence of any such explanation about the difficulties faced by the department, appears to be contrary to the intent expressed through OM dated so-and-so. It is also noticed that the appointment of Respondent 6 itself as the captain advance admittedly has not joined the post till date. 12. Upon due consideration of the case in its entirety, court is of the considered view that the vacancy caused by so-and-so in the post of so-and-so should be considered for being filled up in terms of the guidelines formulated by the state government in the revenue department notification 5th of March 2018, particularly in terms of para 3B and C as already abstracted here and above. In carrying on such an exercise, the respondent authorities, importantly, the Deputy Commissioner of the district court shall make all necessary verifications as may be required, and the petitioner on her part would be at liberty to use any material or documents within her power and possession to establish that she indeed belongs to one of the family of the landowners, and that there was some sort of understanding at the time of handing over the land to the department. The verification, examination, and consideration should be done by the Deputy Commissioner within a period of two months from the date of receipt of the certified copy of this order, and conclude the same by passing a reasoned speaking order recommending the petitioner or any, if any, by giving reasons and initiative and complete within 2 months. In the event if the deputy commissioner finds that the petitioner cannot be considered for appointment on land ownership basis for reasons assigned, then the post of medical attendant which is seen to be vacant on account of so shall be filled up by way of the open advertisement, and in which post both the respondent 6 as well as petitioners should be given fair opportunity to participate. I also agree, even with the second direction bus by this on four. If I'm found to be a non-landowner, if I'm not a landowner, then a direction may be
No,
issued.
no, they are not disputing that
Yes.
you are not a landowner, that they are saying that you are a landowner, but other landowners have already been appointed. That is your ground, isn't it?
Your Honor, if I may, just a moment.
Yes,
This clause 3B, I
yes.
believe this talks about if there is any claim providing employment as a result of oral agreement. So if this clause B would come into effect in determining and verifying whether there was an oral agreement. Not- This does not relate to determining land ownership rights. This is strictly just to determine whether there was an oral agreement. But here in this present petition,
No,
yes,
that is whether there was an oral agreement
yes,
for employment,
yes,
for
yes,
employment.
only for that. But here in this present petition, I would humbly submit that the principle is very clear that the petitioner must first establish the facts and support the claim, which is essential for establishing his legal rights. Whereas in this present case, it looked from reports on hand, the petitioner has not been able to establish his rights, the right to claim employment on ownership basis. Because as per records, it shows that 3 landowners have already been appointed. So the petitioner must first establish his right to be appointed. Only then can the next step of, only then, if his right is established, then this 3B would come to effect, Your Honor. Just on some unfounded claims of the petitioner, it would not be a ground alone to warrant the interference of this honorable court.
Anything else?
My respectful submission.
Yes.
Honorable established my right. There are only 2 grounds.
Is there any interim order?
No interim.
No
No
interim.
interim.
And petitioner 6 has already joined.
More than 2 years now.
More than 2 years.
It is not more.
Yes.
There should be a written agreement or an oral agreement. In my case.
Yes, either written or oral.
Yes. Now, my respectful submission is that in the year 1960, there was only an oral agreement, but it has been substantiated in the year 1989, where an oral agreement was made.
Written agreement.
Written agreement was made, yes, written agreement was made. And that is also being supported by a certificate issued by a statutory body.
If the petitioner is referring to annexure C of the writ petition, this written agreement, it's
Yes.
not between the government and the landowners. It's just an agreement within the village, Your Honor.
This annexure C.
Yes,
Yes.
the government is not a party to this agreement now.
Yes, and then
There's no feelings to that extent that they have denied about it. No availability of denying about the land ownership.
No,
Yeah,
but
only sole contention is-
bare perusal,
Yes,
bare perusal
because
of the
between
agreement.
The
There
village
there
council
is
and
no
the landowner.
signature.
Yes, so even if it's taken that this is an agreement between the village council and the landowners, there was an oral agreement in the year 1960. To that, the state government is not disputing. So my respectful submission is, if 3B and 3C can be invoked, and a verification can be conducted, take into consideration the statements of the concerned department, the district administration and the village functionaries.
And basing on that
Okay.
report, the department can
We'll see. Yes,
take a
yes,
decision.
anything?
Yes, Mr. Roshi.
Yes.
On the way for respondent number 6, I filed my affidavit number 50.
Mm.
And I raised a preliminary objection
Mm.
with regard to locus
Mm.
and my affidavit. However, before I refer to the affidavit administration,
Mm.
Lordship is rarely pointed out. First, the petitioner has to establish his right for amendment on the litigation.
Mm.
Lordship, I'm referring to two paragraphs in the writ petition. The blame of the writ petition.
Paragraph?
Paragraph 2. Writ petition.
Yes.
I'm reading paragraph 2.
Mm.
That by filing the instant writ petition under Article 3 of the Constitution of India, the petitioner is selling the amendment order of respondent number 6 on the ground that she was appointed in the vision of the Constitutional Supreme for public employment, and also bring for a direction to the spot for amendment of the petitioner to the post of multi-tasking stuff against the post held by respondent number 6 on the basis of land ownership. Therefore, since he's claiming for amendment on land ownership, has to establish that is a land ownership right for amendment to the post included. What we kindly come to prayer portion. Page 14.
Mm.
There are two prayers watching.
Yes.
First prayer is considering self-passion, approval and appointment of my client. And second prayer. Direct the respondents to appoint the petitioner to the post of peon, so regulated by so on land ownership basis in terms of oral agreement with between the parties in consonance with the declaration dated 5. The petitioner failed to substantiate his claim that he is a landowner over the establishment in Koshim. And now, Lordship, by filing the
No, that landowners, village council recommendation is there.
Lordship, I'll come.
Mm.
Lordship, by filing the instant writ petition, Lordship, the petitioner is trying to create a new case, Lordship. Lordship, nothing has been mentioned about the gold landowner appointment and her application. Legal notice was also served by petitioner council. Lordship, we come to the application submitted by the petitioner. Now he is claiming that gold landowner has been appointed. That fact was not brought to the notice of the authorities, and now by filing the historic petition, he is trying to create a new case. But we kindly come to page 23 of the application. Is there any mention about all the facts? This is the application submitted by the petitioner, Lordship. Nothing has been mentioned about the gold landowner appointment. Anywhere approached the authorities that he is also one of the landowners. No, Lordship. And page 27. Legal notice was served to the authorities. Here also nothing has been mentioned about the appointment of gold landowners. Just statement has been made that I'm one of the landowner. And by filing the petition, the petitioner is trying to make out a new case that there are two landowners for the establishment portion. Although the other landowner has been appointed, no landowner's permission has been appointed. That is the case of the writ petition. However, no documents, nothing to show that shows that he is one of the landowner. What should we come to my affidavit position? affidavit in opposition of R6.
Yes.
Before I refer to preliminary objection, I just want to point out some documents. Page 13, page 15 lawsuit. Page 15. After filing this writ petition, verification was found by the ANC, the Executive Council of Executive Commissioner. This is letter dated 23/5/2024. Do Executive Engineer BWD Bokobodo Division, Jennifer Nagaland. Subject case has been referred launching. And refers to the above mentioned subject. This office is written later dated 12/2/2024 requesting to verify confirm whether there is any agreement made with the landowners and whether any landowners have been appointed under the division at any point of time and submit the details to this office within 1 week. But even after lapse of 3 months, there is no reply from your end. Now the landowners has filed a case before the Honorable High Court, Kohima bench, and the court by order to dismiss so issued a request which was so. Therefore, you are requested to send all necessary available documents to this office within 1 week. And reply to this letter to be can come to the next page. This is letter dated 29 July 2024, written by the President Executive Engineer, Bogobodo. In response to your letter dated 23/5/2024, I am to state that there are no records or documents available with the government pertaining to agreement made between the government and the landowners. On the other hand, as for the records available in the division, 2 employees, namely Shiri Suinso together and Shiri Suinso the night together, were found to be appointed from Mishilimi village on land ownership basis. Further, Shiri Suinso Sema Beyond who retired on 36/2023 was also a land owner, against which begins Shirimati Motoli Sugi was appointed by this respondent of 66. That is the clarification issued by the Council Executive Engineer Bogobodo. Your Lordship, now the blame of the petitioner in this petition is that the land has been donated by 2 landowners. Other landowner will benefit by agreement of landowners to the great purpose, whereas the petitioner never availed such benefits. And the claim of the petitioner is based on oral agreement. Oral agreement was that to be entered in the year 1960, as per paragraph 4, paragraph 5, the petition. Now we are in 2025. 65 years has gone. What the petitioners and the family members, if at all we are the landowners, we're doing all this days, Lordship. 65 years has already gone. Whether there is oral agreement or not, Lordship, there is not even a whisper from the authorities that there was an oral agreement. No, Lordship. Therefore, Lordship, in view of the appointment of 2-3 landowners over the establishment, the petitioner has no custody to file this petition seeking appointment on landowners, Lordship. Lordship, may kindly come to my affidavit. Preliminary objection, Lordship. Paragraph 2. Number 1, no custody. Paragraph 2, Roman 1. The writ petitioner by filing the writ petition, challenging the appointment of respondent number 6 to the post of 10 days, and bring for to appoint him to the said post on land ownership basis. For appointment of landowners, the government have adopted the policy paragraph provided on that reading. It is stated herein that the respondent number 2, in order to certain the claim of the writ petitioner, white letter dated 23/5/2024, requested the executive executive engineer to verify whether there is agreement with the landowner and whether any landowner have been appointed in the department. The concerned executive engineer by letter dated 29/7/2024 have furnished a report stating that there is no record available with the department pertaining to agreement made between the government and the landowners. By the said letter, information was also furnished to the effect that two landowners, namely Shri Suiso and Suiso, were already appointed on landownership basis. By the said letter, it has been also mentioned that one Shri Suiso, who retired on 36/23, was also appointed on landowner basis. It is on record that many landowners have been appointed as establishment and motion. As such, the writ petitioner have no legal right to claim appointment on the landownership basis, and view of the position laid down by the government status ratio. And as such, the writ petitioner has no custody to file the external petition claiming appointment on landownership basis. Next, Lordship. Petitioner not an incorrect person. Although the petitioner is claiming appointment on land ownership basis, the writ petitioner failed to place on record any documents in support of his claim of land ownership. Even assuming but not admitting the fact that the petitioner is one of the landowners, and view of the notification dated 5/3/2018, the rights of the landowners for appointment doesn't exist, inasmuch as the department have already provided government to numbers of landowners to create those. The writ under Article 226 of the Constitution of India can be filed only by an aggrieved person who has the locus standi to file. A aggrieved person is one who has suffered a legal grievance. A person against whom a decision has been pronounced, which has wrongly deprived a person of something or wrongly affected his title to something. A person aggrieved can file a writ petition, but a person interested may not have the locus standi. A writ petition under 226 of the Constitution of India can ordinarily be applied by a person who has a personal or individual right in the subject matter of the application. And in this case, the petitioner have not been denied or deprived of any legal rights or sustained injury to any legal protected interest. And as such, the petitioner is not an aggrieved person. Therefore, the writ petition is liable to be dismissed. In support of my petition, Lordship. On one or three, and two judgment in that by the Lordship. First, Lordship, 2013. For SEC. 465. I'm relying on four paragraphs, paragraph 9, then 11 and 17. Paragraph 9. You have to find page 475. Versus agree. I'm going to also person. It is still legal proposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority court that he falls within the category of the great person. Only a person who is suffered or suffers from legal injury can challenge the action, order, etc. in the court of law. A writ petition under 226 of the Constitution of India is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which the writ jurisdiction is resorted to. The court can, of course, enforce the performance of the statutory duty by a public body using its writ jurisdiction at the behest of a person, provided that such person satisfies the court that he has a legal right to insist on such a performance. The existence of such right is a condition precedent for invoking the writ jurisdiction of the court. It is implicit the exercise of such extraordinary jurisdiction that relief grateful must be one to enforce a legal right. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction by default. I'm still remaining paragraph 10. A legal right means an entitlement arising out of a legal rule. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not involve a person who suffered from a psychological or an imaginary injury alone. A person aggrieved must therefore necessarily be done whose rights or the interest has been adversely affected or jeopardized. And paragraph 11, proceed. And another case law. A similar view was taken by this court, observing that if a person claiming relief is not eligible as a deferment, then he cannot be said to be a person aggrieved regarding the election or selection of. Lordship, we kindly examine whether the petitioner comes under the category of a person. Unless he satisfied that he's a aggrieved person, the power of this court under 2 weeks cannot exercise law. And no mandamus can be issued.
Yes, next.
Please note the next judgment, motion. You're not by lordship. This is judgment. That is 16/5/2025. What do you mean, kindly? I'm reading paragraph 2. What is the facts?
Yes, I remember this. Here also there were 2, 3 landowners who had been
Well, but
appointed.
Therefore, this one can conclude that the petitioner who is claiming appointment on land ownership basis is not a great person and dismissed the petition. So a great person has been considered by this honorable court and this judgment of it. The conclusion arrived to by lordship is in paragraph 16, 17, and 18. Holding that the petitioner is not an agreed person, therefore has no past knowledge of proof. And what I took as a 226. That was the finding of the lordship in this judgment. In the same time, I'm not reading this judgment. And another judgment. The similar language. This one also. For lordship judgment. And the same question of law. A good person, here also two landowners. Landowners were already
appointed.
And therefore can do conclusion that the petitioner is not an agreed person and has no longer study to challenge the appointment of the prime respondent. And also not within this process, please. Lordship, subsequently, with petition lordship, we can come to lordship. I'm reading paragraph 11, lordship, before I refer to the lecture.
In your affidavit.
Yes, paragraph 11. Page 8. Mayor lordship.
Yes.
That with regard to the statements made in paragraph 13, 14, 15, and 16 of the petition, As stated in the preceding paragraphs, it is on record that numbers of landowners have been provided employment to the paid for posts. As such, the writ petitioner do not have accrued any legal right to claim for appointment on land ownership basis in view of the notification dated 5/3/2018. It is stated here that the writ petitioner is claiming appointment on land ownership basis on one hand, and at the other, at the same time, is alleging that respondent number 6 was appointed without the selection process. The writ petitioner himself failed to make out his case whether he is agreed by non-constitution of his appointment on land ownership or filling up the post without evidence. Therefore, the writ petitioner shall not be allowed to appropriate and reprobate on the issue of filling up the post in question. The condition of the writ petitioner is nothing but afterthought, which the writ petition deserves to be dismissed. This important worship. It is also stated herein that even assuming but not admitting the fact that the writ petitioner is one of the landowners of the executive engineer BWD Bogobado division, Zenibodo. At present, the said establishment has been shifted to another location over the government acquired land. The office of the executive engineer BWD Bogobado division, Zenibodo, is now within the new administrative complex at Bogobado, which was recently inaugurated on 16/10/2024. The new administrative complex was established over the government acquired land. As such, appointment of landowner on land ownership basis and establishment in question by the arrears. Let's go back to page 33. The establishment in question where the petitioner is seeking appointment on land ownership basis has already been shifted to government acquired land. This is the program worship.
So it is no more there on his land,
No,
alleged land.
it's acquired land. Therefore, even assuming that he is one of the landowners in the elsewhere establishment, establishment of it, that is basically government acquired land. No landowners have rights over the owners.
This is 24.
Yes,
Yes. Hmm.
after filing the writ. After filing the writ.
When the writ petition was filed, that it was still on that land.
Therefore,
That may not be.
Either way, writ petitioner has no custody to claim appointment on land ownership basis. Therefore, Lordship, my prayer, my submission is that Lordship. This honorable court, without entering into the merit of the case, with regard to appointment of explicit Lordship, the writ petition deserves to be dismissed. As the writ petitioner has no custody to file a petition. And as much as he is not come under the category of active person. Therefore, Lordship, without making this submission to my appointment, Lordship, my humble submission is the petition deserves to be dismissed. On the ground of the custody and every person. Lordship, lastly, Lordship, there is the word situation, and even this Lordship entered in the merit of the case. Respondent number 6 is already of age. For under public employment. She is 38 years now. Put that aspect going to the middle of situation. And the event, this court entered into the merit of the case.
No, we cannot interfere at this stage because already 2 years she's been serving and there's no interim order also.
Yes. What's up?
Yes.
May I note
Yes,
one of the
yes.
grounds.
Mm.
Firstly, on the argument advanced by the council correspondent 6 with regard to aggrieved person. I fall into the definition of aggrieved person because I have donated my land and that has not been disputed by the government, very specifically by the government. Now, my land has been taken away and I cannot be deprived of my right under Article 300A of the Constitution. It is not disputed.
But what about
And
that
for-
letter of the EE where it said that there is no record of any agreement?
Proper verification conducted, because that is only the opinion of the EA. As far as 3B of the notification is concerned, the village functionaries as well as the district administration, they should be present, their statements should be recorded. And if there is any dispute regarding the facts, that will be decided before the appropriate forum. But it is only the opinion of the executive engineer. No proper verification was conducted in terms of 3B. The certificate issued by the village council is not disputed in this case. Secondly, with regard to the authority which was relied upon, WPC 333 of 2022, Shri Chungshinok's Lokumer's case, that was a challenge against the appointment made on compassionate ground. Compassionate ground, and that was in terms of the notification for compassionate appointment in the year 2015. The appointment was made in terms of the notification for compassionate appointment. And in that particular case, this honorable court has given a direction for verification. Verification was conducted while pending the read petition. And on submitting the report, it was found that the petitioner had already availed the benefit of employment as far as Chungshinok's case is concerned. So it is factually different. Cannot be applied in my case. My case is very particular. It is very specific that the coal landowner, they have already availed the benefit, whereas in my case, I'm yet to be given the benefit. In fact, the senior counsel for respondents has pointed out, and I really appreciate that they have occupied my land for more than 6 decades. I cannot be deprived of my rights. They cannot take a stand, and that is the stand specifically taken by the private respondent, not by the government, that the establishment has shifted while pending the read petition, disposal read petition. That cannot be the stand. They have illegally acquired my land. They have not given any consideration for the land, and now they're going to come before the court, making a stand that they have already shifted. They have illegally possessed my land for more than 6 decades. They cannot take the stand. Of course, with due respect, that is only the submission of the private respondent, not the government. Now coming to the appointment. Yes, there was no stay order. I have approached this honorable court after nearly a year. I have submitted my reasonable submission before this honorable court. I'm not pressing for the interim because I have missed the bus because I approached late. That doesn't necessarily mean that the illegal appointment cannot be recognized. She entered without any selection process, that cannot be made to stand. If she entered illegally, she has to go out illegally. She has to be out of service. And I have some authorities as far as the illegal appointment is concerned. It is in clear violation of Article 14 and 16. No appointment can be made without any selection process. They have not shown, the government has filed the affidavit as well as the private respondents, nowhere, not even a whisper in the affidavit stating that there was selection process. And in order to establish my rights, I have clearly categorically stated in my read petition, there is oral agreement, it is supported by the certificate issued by the village council. I have established my rights. And if there's any dispute, verification can be done in terms of the notification to know the agreement.
But even if verification is done and it is found that you are a landowner,
Yes,
but other landowners already appointed,
it is the full landowner, not the full landowner. Now I have to leave in my land just because the co-landowner has availed the benefit. I cannot be deprived of my right. Which is why
in another
so
case,
forward.
that WPC 89 of 23 also, it was a similar case. There were three landowners.
My
There are also
submission,
two.
my
Yes.
respectful submission.
Yes.
There's also, if a direction can be issued under 3B, where at least a verification may be conducted. I'm not seeking for direction that I should be appointed. If I want to be a GL,
Kindly go through the prayer. Just for. Lordship. No doubt. As a power of the process 6, we should need directions.
Yes,
Prayer is also by prayer, they kindly believe.
Yes, yes. As far as prayer is concerned, it's only for quashing that respondent number 6 and to
We have to
appoint.
go by the bladings.
my respect. So for sitting under 6.
No, no, that any direction.
Within the notification, my prayer is within the notification.
And now with regard to shifting up the complex, the administrative headquarters of.
Hmm.
I file my affidavit and I enclose the program also. The writ petitioner filed your
No.
affidavit in reply.
Hmm.
There's no part about that. There
No,
was
no,
some
that is a
application-
different thing, because that was only after filing, because when they applied, that complex was still there. Yeah. We'll see whether any consideration can be
Yes.
made. I'll dispose chamber, dictate in the chamber.
Okay.
This to the chamber. Yeah, this one also. I think printout is better. Yes. After 5 minutes. Okay.
for hearing item number 9.
Minutes. But
Yes.
issue in this case, if my list can hear me,
Hmm.
is that the writ petitioner, he was employed in 1984.
No, the submission of the government council is to adjourn the matter.
So the disposal of the
That is what I'm contesting.
Read appeal
Yes.
2, 3, and 4.
And this is not an isolated case, in this bench.
So when did this case can be decided?
Cases are.
Yes.
Kept pending.
Evidence.
No minutes.
For the disposal of the.
Yes, yes, exactly. In other cases also, this court also has passed orders.
I would have
Ah,
kindly consider.
similar cases.
Yes, Miller, exact
Yes.
similar case. Court comes to speak. In fact, minutes earlier,
Hmm,
the state took, they got the matter kept pending,
hmm,
saying that this is a DB matter pending before, pending before the honorable DB,
hmm,
and let it be decided first.
hmm.
Order may kindly be seen minutes.
Hmm.
Learned Advocate General Nagaland, after arguing the matter for quite some time on merits, has submitted on instruction that he wants to withdraw this writ appeal. And thereafter, in view of the above, this writ appeal is dismissed as withdrawn. However, the state of Nagaland is directed to comply with the directions given by the learned single judge in the impugned judgment in order within a period of so and so. So Millet's issue is already considered by the DB. They have withdrawn because
That was not
it's
contested, it was withdrawn, Your Lordship. But in this case, the writ appeal which is pending before the Kohima bench, Your Lordship, the government were contesting on low points, Your Lordship. So when the issues related to the
after
law
this,
points
what
pending
remains?
for the division bench, Your Lordship, whether this single bench cannot take up this matter, Your Lordship. I mean, this is not an isolated case, as I said earlier, sir. Many
Millet's-
cases related to retrospective legalization has been kept in abeyance, Your Lordship. And there's so many
Millet's
others.
in that case,
So in,
if this is the stand of the state.
hmm,
Millet's here, it was contested. In fact, the Honorable DB has recorded that arguing on merits for quite some time. The argument by Learned Advocate General has taken place on merits and for quite some time. But this is the case was totally indefensible, state withdrew. And thereafter, the Learned DB was pleased to direct to that Learned Single Judge order should be implemented, which is exactly my case. I'm covered by that. Now, Millet's, because the state has a large number of such cases, I do agree with my learned sister. All those cases are coming one by one as and when they are getting a hearing about it or whatever. So can the state say, that is what I'm framing for my law's consideration. Can the state say that unless and until every single appeal which they will file against every single judge bench order is decided by DB, no other single bench matter should be
no,
considered?
no, I think what they mean is since the DB has already taken cognizance of these cases, similar cases, and is going to be decided on the law points, So in similar matter, whether the single bench can also, adjudicate.
That is exactly,
Mm.
then I will give the judgment from the Honorable Supreme Court. Once there is no stay,
Hmm,
there is absolutely no bar or invocation of jurisdiction of this bench or any other bench, because every court is a court. Ultimately, these are intra-court,
Of course.
concepts, single bench or double
course.
bench or full bench. So ultimately, it is the High Court of, Honorable High Court of Gauhati, which is seized of the matter. So Millet's,
These writ appeals, are they at the stage of hearing or what's the stage?
Admission, I think, Your Lordship, I'm not really sure.
so
It was not
either,
listed for some time, so.
Hmm,
Millet's, either the state should have obtained a stay, then of course they could have argued, because the DB has given a stay on the cause of action. Now Millet's, because the state of Nagaland, so many historical factors are there, because of this large number of people are working in such situations. Other state, in fact, I'm prosecuting some matters of about 100 odd petitioners in the Honorable Supreme Court in the Health Department. The Honorable Supreme Court is seized of the matter, reply is not being filed. The court has said that next date they will decide on merits if the reply doesn't come.
Mm.
So Millard, there are a large amount of litigation, I do agree. But point is, Millard, think of the plight of this poor person. Ultimately, it's a question of human rights. We are a civilized state. We are not some banana republic where we can go on abusing citizens like this. In fact, I am raising an issue of bonded labor. She has been treated like a bonded labor. Can this honorable court permit a person to work for 35 years on a bare survival remuneration of 3,000 rupees in 1900 and 2019? And then, my lord, she is sent home unceremoniously that you have turned 60, we cannot have you.
Lordship, that's why on law points, your lordship, we have to.
So
wait
where is
for
the law point? This
One has to wait for
the conduct of the state is highly abusive. In that case, my lords, may I suggest, I have moved an interim relief. Let the state also show some bona fide. At least something should be given to her to survive. She needs 2 meals. She is an old woman of 66 years now. And the state is not ready, and the state is raising frivolous issue that DB matters are coming up. You have gone in appeal. DB has not found any merit in your case to give you any interim relief.
What happened? She didn't come under that
No, your
scheme.
She-
That
She was a contingency paid employee, so they were not covered by that scheme, your lordship.
Millards, that is the stand of the state. But the learned single bench, now upheld by the learned division bench, it has not been accepted. Once the state has taken, state is the state, Millards, it is not even a private employer. Once the state has taken the work from a person for 35 years, they cannot raise these clerical issues. That is what Honorable Apex Court has said in the state of Punjab versus Jagjit Singh. So, and I'm giving Millards a series of compilations. And Millards, I have made a compilation of a series of judgments which are covering issue entirely fully, not only this honorable court, Millards. It's covered by the whole issue is covered by the honorable Apex Court also. That's why the state-
do you have the judgment of the coordinate bench in this Pihoto Sema Kikito Sema?
Yes, Millards, yes, Millards, yes, Millards. Millards, we have certified copy, Millards can see.
See, in our it's like this. In this WPC 112 of 2019,
Yes.
the petitioners were similarly situated with the petitioner in this case. So as they were serving on fixed pay on contingency basis. And then the coordinate bench directed to consider the case of the petitioners and regularize their services within 2 months from the date of receipt. Then after that, this writ appeal 68 was filed by the government, 68 of 2021. Then on 18/3/2025, it was withdrawn.
Your lordship, that's why.
Mm,
my
it was
understanding,
withdrawn.
Since it was not contested, I don't know.
No, withdrawn means, and see the next line. Withdrawn, and the
means
state of
conceded.
Nagaland is directed to comply with the directions given by the learned single judge in the impugned or judgment and order within a period of 4 weeks. So
They're contempt pillars of this honorable court, they are not complying with any order. They are raising completely frivolous grounds to go on.
So when under similar facts and circumstances, this court now has to go by a similar order. When you cannot produce any stay in the other petitions. That is the view of this court.
If that's the case, like, this can be taken up some other day. Lord. Not really,
Then
but
you
then-
take the instruction, you just say that the court is of the view, this court is of the view that it is squarely covered by this WPC 112 by a coordinate bench, against which the state had already gone in appeal and withdrawn. And the division bench had given the direction to comply with the directions of the single judge. Okay, then this court is also bound. So we have to pass a similar order.
And get it complied with,
Mm.
that binding of the the directions of the Honorable DB becomes binding on this single bench because of the larger, larger estate.
That's why.
And let's kindly see in this case only, let's, I will request kindly see the order of 12th September 2024. In
I have
the-
understood your case, but she needs some time for
Oh, that's
instruction.
okay, let's.
So, yes.
Against her, he's doing my job.
So
No,
you.
let's with due respect, I'm saying.
Hmm.
Either the state should argue the case and let the honorable court decide.
Hmm.
Or some interim relief I am praying. Well, we are not able, she's not in a position, in fact, my associate is giving her money to go back.
What sort of interim relief?
Millets, I am praying that the state is a state, Millets. The state is
Hmm.
not bound by these clerical rules.
Hmm.
Honorable Minister, that the governor
Hmm.
has all the powers under the financial rules as well as the constitutional provisions.
Hmm.
Something, at least bare subsistence, 2 meals a day. I'm praying for that. We are spending money from our pocket.
That we cannot.
Millets, that's why I'm
cannot.
combining with
Hmm.
other cases so that we can save on, so she's not in a position to even buy the bus tickets. My associate gives her money to come back and go to tell us. She's living in her village in Bokha, somewhere near Bokha. So Millets, she's in a very precarious condition. And she has served them for 35 years, Millets. There are no grievance against her service. Of course, they can
When
have
can
an
it-
issue that she has turned.
Next week.
After 2 weeks, Your Lordship.
No. Just for that only one phone call will do.
In fact, Millets,
With the
the concerned secretary should be called.
Or you can talk
In
with
the-
the additional AG also, Advocate General, and then
the instruction on the epic which is pending before the Kohima bench.
yes. That also, and regarding this petition, because now this court has to pass necessary order in view of this coordinate bench order as well as read with this division bench order, where the government had already gone in appeal and withdrawn, and division bench has given a direction to comply with this, with the directions of the single bench.
And Millets,
Isn't it?
So.
So
again,
now-
I'll take that.
You take the instruction and then we'll have to dispose it of.
And Millets, what was the undertaking of the state? With due respect, I'm just bringing to the court's notice.
Hmm.
The order in our case, the present case
Hmm.
of the 12th September 2024 minutes, order sheet, 12th September 2024.
12 September to
2024 minutes. Twelfth September minutes.
yes.
Heard Mr. N.J. Lotha, learned counsel for the petitioner and Miss so-and-so. By the order dated 25/7/2024, Miss Inaholi was directed to produce the copy of WA number, the direct appeal which has been withdrawn. Since a submission was made, the subject matter in the present case writ petition in the pending writ appeal are the same. The learned government advocate has produced a copy of the writ appeal, so-and-so the court has perused, and it is ascertained that the subject matter in the present writ petition and the writ appeal is similar. It is, however, submitted by the learned counsel for the petitioner that in WA number 68 of 2021, no stage has been granted against the order passed by the learned single judge. That is our contention. The parties have also submitted that the pleadings have been completed. Considering that WA 68/2000 is pending before the Honorable Division Bench, this court is of the view that present writ petition be listed after the disposal of writ appeal by the Honorable Division Bench minutes. So writ appeal was disposed, then matter came up, and then matter was listed for final arguments by the previous court pleas.
Hmm.
With due respect.
Hmm.
Again, they are coming with same. Once we wait for these, again in meantime, some more litigation will come up.
No,
Meaning thereby indefinitely, this person is already.
no further time on the next
So
occasion.
Millets, there is absolutely no merit in the contention of the state. Millets have the jurisdiction, Millets can exercise jurisdiction with due respect on merits. In fact, now.
Yes, you listen, I'll just pass necessary orders. Heard learned counsel from Mr. Such and such for the petitioner and Miss Inaoli for the state respondents. Stop. At the outset, learned counsel for the petitioner has submitted that this case has been kept pending due to the submission of the learned
To
government
await the
advocate
that,
that
68 of 2020.
yes, that similar petitions are similar issues are pending in writ appeal 2 of 2025, 3 of 2025, 4 of 2025, and 68 of 2021. Stop. Today, when the matter is called, the learned counsel for the petitioner has supplied a copy of the order passed by the
Honorable DB.
Honorable Division Bench on 18/3/2025 in writ appeal 68 of 2021, by which the learned Advocate General Nagaland has
After arguing for. quite
after
some time.
arguing for some time
Yes.
has submitted that he wants to withdraw the writ appeal. Stop. Accordingly, the learned division bench, Honorable Division Bench allowed the withdrawal of the writ appeal and directed the state of Nagaland to comply with the directions given by the learned single judge in the impugned judgment and order within a period of 4 weeks. Stop.
And thereafter,
This-
the decision court listed the matter of final arguments. So at that time also, they didn't raise this issue.
I raised the issue, Your Lordship, but it's just that it was not recorded.
Last order may kindly be
It
seen.
is not recorded.
No, it is in this case, kindly see last order minutes of this case.
This case, yes,
Yes, last order minute, last order.
16/5.
In Honorable Justice, he superannuated minutes. So he was superannuating, so he said that we will not have time to pass the order. So he's fixing it for final hearing.
It's okay, it's okay. So this court has seen that the facts of WPC 112/2019 are similar to the present case. In WPC 112 of 2019, a coordinate bench of this court by judgment and order dated 16/9/2020 had directed the state respondents to consider the case of the petitioners and to regularize their services in terms of the rulings of the apex court within a period of 2 months from the date of receipt of a certified copy of the judgment and order. Stop. This court is accordingly of the view that a similar order needs to be passed in view of the dismissal, in view of the withdrawal of the writ appeal 68. Okay, disposal of the writ appeal 68 of 2021, wherein a direction was given to the respondents to comply with the directions of the learned single judge in WPC 112 of 2019. Stop. Accordingly, list the matter after 2 weeks. You want a fixed date?
Minutes we will combine with other.
Okay.
other.
After 2 weeks, and on which date the endeavor shall be made to dispose of the matter. Stop. The learned government advocate is directed to receive instructions regarding the same. Yes.
Good.
This one, you'll take it back or?
Minutes, I will be referring, so minutes can have it on record. I will be referring the judgments.
Okay, then you just get it together. You're coming from Delhi or
I come
Gauhati?
from Delhi minutes, but
Hmm.
Mr. Lotha is local.
Okay.
So he has studied from Delhi. He did his LLB and then just like minutes and his LLM. Then he, of course, I was in government service minutes. I'm 87 batch IRS officer.
Okay, okay.
So I came in contact with a service lawyer with whom he trained. So when I got myself enrolled after superannuating, then he had joined. We have joined, so we are working together.
Well,
I normally appear in Supreme Court and High Courts. But since this is an issue which is very, I will say not interesting, but it is something which is very, pro bono. So we said we will take it up and do it. So that's why we are grateful for this.